I will put him in jail if he doesn't do the things I tell him to do. That's the only tool I've got in my toolbox at that point is jail.
Yeah,
Hopefully he wants to do what I want him to do more than he would rather do what I want him to do than go to jail, because if I'm trying to force him to do something, all I can do is jail him.
I know, because
if he's willing to go to jail rather than do what I tell him to do, he's going to jail. If that happens, and I have every reason to believe it will, I'm going to order that he have a professional mental health evaluation done. Okay. And then if they recommend a course of treatment, I'm going to order him as part of my probation to follow that course of treatment. Now, I want you to understand, I can only order, I can't make sure things happen. Now, I just want to make sure we're on the same page. Yeah. I'm getting more and more conditions on plea agreements. I just want to make sure you understand that I'm not accepting pleas subject to those conditions. I will take recommendations, but when I put somebody on probation, I'm going to send it to my probation department to decide what the sentencing term should be. The prosecutor's office is not determining sentencing for me.
Okay.
So as long as that's just a recommendation, I don't want you to think it's an agreement and that's what's going to happen going forward, because I don't know that until I have this individual met and interviewed by my probation.
And that's fine, Judge. It's a strong recommendation if you're not going to accept it as an agreement. Right. In regard to felonies, it is a different situation, of course. But in regard to this case, the mental evaluation, all those things, they have weight to why I'm stating them. There's things that
I'm more than willing to accept them and recommendations. I don't want anybody to think it's somehow binding on the court. I don't want you to come back in 3 months and say, I want to take away this deal because he didn't get what we agreed to. That's where I'm going with this. Okay. I don't want you to send it in thinking that's what the sentence will be. I'm certainly going to consider your recommendations. Okay. But yeah. I just don't want it to be, it's like, this is nailed down because we've agreed to it, because we haven't agreed to it, you've agreed to it, and I sentence. I just want to make sure we know that going forward, that it's a recommendation to me. It's not a condition that I'm accepting the plea under.
Okay. And I understand that. Okay. And I guess I just want to make it very clear that in this situation, I've had conversations with the victim.
Right. And I'm going to. I'm going to give her a chance to talk in just a minute.
Yeah. And those conditions are based off of my discussions. So, for example.
No. Hold on. Stop there. I would be mad at you if you put some conditions in here that you just pull out of the air. So when I see these, I assume they're based on your understanding of the file.
Okay, yes.
I just want to make sure that you don't somehow think that it's going to happen that way because it's on this piece of paper.
I understand.
Okay. All right.
I would, I'm sorry, last thing.
Yeah.
The only thing I will say is that in this specific case, those recommendations are strongly encouraged. And
I got you. And I will probably adopt them. I just want to make sure you understand that I'm not going to adopt them based on this paper. I'm going to adopt them based on the fact that after an interview, my probation department recommends them.
And I'm okay. I'm
okay.
Glad.
And those recommendations have been shared with Mr.
No, I know. But I just want to make sure you guys think you got an agreement, but this is sentencing. That's the court's purview, not the parties. I just want to make sure we're all on the same page. Okay. All right. So thank you, Mr. Muhammad. So Mr. Williams, you've discussed with Mr. Bowditch your rights and options, correct?
Yes.
And you understand those rights and options today? Mm-hmm. And you understand the possible penalty for this charge?
Yes.
All right. And lastly, you understand when you say no contest, you're literally saying, Judge, I'm not fighting that charge. So if I find a factual basis to accept the plea, I'm going to go forward and ultimately there'll be a sentencing. You understand all that? Okay. And understanding all of that, are you pleading no contest freely and voluntarily today? Mr. Bowditch, is there an incident report?
Not that I have one.
I don't see any paperwork in the file that give me a factual basis.
I believe Mr. Muhammad is retreating.
Thank you. Mrs. Williams, do you mind stepping up here so I can hear you?
Would you just, Judge may have some questions for you. Would you just tell the judge your name for the record, please?
Thank you, ma'am. What would you like me to know?
I just like to know that, let you know that my son really isn't a threat to me. He just needs help. I've been trying to get him help for the last since 2017, and everybody just assumes that he's just a regular drunk, and that's it. But it's not, it's getting worse.
Okay.
So I need to see, I have been trying to seek help for him, but they just won't help me. So
Yeah, it's hard.
I had to do this in
It's
order
hard.
to try to get some help.
Yeah.
My son, so he
Well,
can.
let me tell you what we're gonna do. Okay. He's gonna be interviewed by one of my probation officers.
Mhm.
There's very little doubt in my mind that the probation officer is gonna suggest the same thing that you're telling.
Mhm.
If that happens, and I have every reason to believe it will, I'm going to order that he have a professional mental health evaluation done.
Okay.
And then if they recommend a course of treatment, I'm going to order him as part of my probation to follow that course of treatment. Now, I want you to understand, I can only order, I can't make sure things happen. Now, I will put him in jail if he doesn't do the things I tell him to do.
Mhm.
That's the only tool I've got in my toolbox at that point is jail.
Mhm. Yeah, but
Hopefully, he wants to do what I want him to do more than he would rather do what I want him to do than go to jail, because if I'm trying to force him to do something, all I can do is jail him.
I know, because
If
has
he's
an
willing to go
alcohol
to
problem
jail, rather than do what I tell him to do, he's going to jail.
too. Okay, because he has an alcoholic problem too on top.
Well,
of that. That's
there-
making it worse.
I'm not gonna
That's
send him,
making-
I'm not gonna send him for a mental health evaluation that would miss that,
Okay,
okay?
okay,
So it could very well be that part of his course of treatment is gonna be mental health, and part of it's going to be substance abuse, so he's working on everything.
okay.
But I want you to hear my heart, ma'am, because I hear yours. I'm not going to punish your son.
Mhm.
I'm going to formulate a sentence to give him help. If he continues to refuse my help, then I will probably put him in jail as an attempt to make him take the help.
Mhm.
Understood?
Mhm.
Is there anything else you want me to know?
No, I just, whatever you do, I'm
Your Honor,
support.
there is also no assaultive contact. That's what.
Okay,
Yes.
okay, all right. And you're hearing me, right? So you understand how serious I am. If I tell you to do something on probation, it's because I think it's better for you. I do find a factual basis to accept the no contest plea. Get that back to the pigs. All right, as I mentioned a couple times, Mr. Williams, I'm going to send you downstairs to the probation department, and they're going to set up that interview, and they'll also tell you when you're going to come back for a sentencing date. And that's when you and Mr. Bowditch and myself will have another conversation. And Mom, you'll be invited to that as well. You don't have to come, but you'll be invited.
Okay, thank you.
Is there a no contact now?
I believe probably there was one entered, Your Honor, but now it's no assaultive contact.
Okay, all right. Are you okay if is Belridge your address, Mom?
Yes,
Is it okay if he comes back there as long as there's no problems?
yes.
Okay, so I'm gonna refer him to the probation department. I'm gonna change the bond. Everything's in place,
Okay,
except instead of no contact with you or that address, you can have contact as long as there's no further problems. You understand that?
Yes, sir.
All right, anything else?
Nothing, Your Honor. For the record, Jeffrey Bowditch appearing on behalf of Mr. Hinkle. Mr. Hinkle, can you tell the judge his name and address, please?
Gary Hinkle.
Thank you, sir.
Thank you, sir. Your Honor, today's date is time set for pretrial for Raymond in this matter. We waive formal reading and standing. We've also had a chance to pre-try this case, Your Honor. In this matter, Mr. Hinkle wishes to plead guilty to the charge of operating while intoxicated with the understanding the charge of operating with a high BAC would be dismissed.
Thank you. Sir, is that true? You understand the purpose, or excuse me, you understand the rights you have and the options those rights give you?
Yes, Your Honor.
And you understand the possible penalty for the added charge?
Yes, sir. I do.
Understanding all of that, are you pleading guilty freely and
Yes.
voluntarily to
Yes,
that
sir, I
charge?
am.
Excuse me. Sir, did you drive a vehicle in Huron on April 18, 2024?
Yes, sir, I did.
Prior to driving the vehicle, did you consume some alcohol?
Yes, I did.
Did you take a breath test or a blood test?
It was blood test, Your Honor.
Do you know what the results were?
We're trying to effort that as we speak. Your Honor.
Okay. Well, let me ask you this. Looking back on it now, do you think that your ability to operate that vehicle on that date and time was materials?
Looking back on it now, I don't believe so.
You don't?
I don't think I should have been at the day that it happened. I had drank earlier in that evening.
Mhm.
I'd laid down and went to sleep. I thought I slept enough to sleep it off,
Right.
and I was on my way to work.
Okay.
Do you
Okay.
think had it not been for the alcohol, you would have driven better?
Oh, most definitely. I think that's
So
what
you
hindered it.
believe,
Well, let's do it
you
this way.
believe it was you believe the consumption of alcohol influenced you on that day?
Yes, sir, I
And
do.
that's what caused the accident?
Yes,
I know you don't remember the actual blood alcohol level content, but do you know if it was more than 0.08? Do you remember that much? If you don't remember, that's all right.
Your Honor,
They
he
never
was in
told
an
me.
accident, pretty tragic.
Okay,
I hit a tree and rolled my car like 5 to 7 times, and they said I was lucky to actually even walk away from.
Sounds like it.
At the time.
But
Okay.
considering the fact it was offered as a high BAC, we would stipulate to it being above a 0.08.
then I can accept the plea.
Thank you.
All right, I'm gonna do two things. I'm gonna send you to the probation department to schedule an interview. You heard how I explained it to
Yes.
Mr. Williams, the same way. It could be an interview, report, recommendation, we'll all talk about it. And I'm also gonna put you on a personal bond.
Okay.
Bond is conditioned, number one, stay out of trouble. Number two, cooperate with probation so we get you back here for the sentencing date. Number three, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. You
Yes,
got
sir.
all that?
Yes, sir.
Any questions about any of that?
No, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to court now $1,000 if you screw up on bond?
Yes, sir. I
You
do.
screw up on bond, you go to jail, it's gonna cost you $1,000 cash to get out.
Yes, sir.
Questions?
No, sir.
Go downstairs and good luck.
Thank you, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, I believe that might complete on schedule for today.
I got the file already.
Okay.
Mr. McCarter, I got an email. He is in Maple Grove Rehab. He was been there ever since the 1st of July.
Good.
He will be there till the end of July, but I have scheduled him. I've asked for an adjournment till August.
Okay,
But I just wanted to let.
she's on it.
He
Yep.
had an excuse for his absence.
Appreciate it. Thank you.
Thank you, Your Honor.
Counsel, are you ready on Johnston?
Yes, Your Honor.
Come on up. Good morning, gentlemen.
Good morning.
Your appearance, counsel.
James Anderson appearing on behalf of Mr. Johnston, who stands to my right. State your name.
John Johnston Jr.
Good morning. What are we doing?
Your Honor, we have a negotiated plea this morning. The prosecution has graciously allowed my client to plead guilty to a misdemeanor charge.
Less than 200, right?
Yes. With restitution, of course.
Rights and options with Mr. Anderson?
Yes,
You understand those?
yes,
You understand the possible penalty for the added charge?
yes,
Understanding all of that, are you pleading guilty freely and voluntarily to the added charge today?
yes.
Counsel, would you voir dire? Give me the facts I need. Incident date, if that helps you, counsel, is April 20, 2022.
Sir, on the date of, I'm sorry, the court date, June 7th, 2022. I got
May 20, or excuse me, April 2022.
Sir, on or about April 20th, 2022, were you employed at Amazon?
Yes.
Where's that located? And in the course of working at Romulus, did you take some items that did not belong to you?
Yes.
Do you stipulate that the approximate value of the items that were taken was $17,322.99?
Yes.
And you didn't have permission from your employer to take those items, did you, sir?
No.
I have no further questions.
Are you satisfied with the factual basis, counsel?
I'm satisfied. with
So am
that.
I. I'll dismiss the original count, one misdemeanor or felony.
Thank you. John.
Any criminal history?
None.
Are you okay with an immediate sentence?
Yes. Yes, please.
What should I consider?
The fact that Mr. Johnson has no prior record. He comes from a very supportive family. His mother is present here in court today. Understanding the thing that he did was wrong, notwithstanding that he has a pretty good work ethic and has already secured another job.
Where at? Sorry to interrupt, counsel.
O'Reilly's,
What do they do?
car parts. It's in
Oh, that
Belleville.
O'Brien's.
Yes,
Okay,
it's on
okay.
Eco's Road.
Go ahead, counsel.
And that, I believe, will go a long way in terms of him.
With the prosecutor, I'm gonna do a probation only, no jail time. I'm gonna put you on for 2 years. Probation fees are $600. I'm ordering 40 hours community service, and I'm ordering the restitution amount $17,322.99. Community service means charity work. As long as the organization is registered as a 501c3 with the IRS, so church, soup kitchen, Salvation Army, We've got a list of organizations in our area that are pre-approved. Westland, so our agencies are probably close enough for you. You can find something on your own. I'm just gonna make it easier by giving you a list. If you do pick something on your own and you have any doubts that it might not be approved by the court, get it pre-approved before you do 40 hours of community service, all right? I'm gonna do a non-reporting probation, counsel.
Thank you so much.
So obviously, on an O'Brien's paycheck, this is gonna take a while. But I want you to start making some regular payments, and I want those payments to hurt. You know what I mean? Okay. So the reason I put you on 2 years probation is because I think this might be one of the worst cases of brain fart I've ever seen. But at your age with no criminal history, I'm assuming this was just temptation. You couldn't handle it. But I figure in 2 years, if you're going to recommit, or if you're going to commit another crime, you'll probably do it within the 2 years. And at that point, I'm going to put you in jail. That'll be a violation of probation. You'll still have the new crime to deal with, but that's a violation of my probation. I'm going to put you in jail on this file. Clear?
Yes.
So go find another job because you need to be working 80 hours a week. All right. Anything else, counsel, by way of clear? Oh,
Yes, Your
did I
Honor.
tell you what my fines would cost are $1,500, then the restitution.
One other matter.
Go ahead, counsel.
Perhaps as an additional incentive, would the court consider closing out probation early if he makes all fines and costs paid within?
If he can get the rest, obviously, as you know, the restitution is my main concern, that and no reoffending. If he can get the 17,000 paid off, absolutely. I'd love that request to be made.
Thank you so much.
Okay.
Thank
I mean, that shows me that he's taking this seriously, and then I'm not so concerned about it, a new offense. All right.
Thank you.
Okay.
Thank
Any
you.
questions, sir?
No.
Good luck.
Your Honor, is he still to go to probation?
Yeah, he's gonna have to go down there just so he can get all the contact information, make sure it is right. Get him started. You can get a list of our organizations that are already pre-approved.
Thank you.
Okay, you're welcome. Have a nice day. Officer Crova, did she tell you about the birthday wishes?
I heard that people are singing. I want to thank everybody.
Are we able to do all the no-shows on the misdemeanor docket at least? All right, appearances on Thomas Basher, please.
Good afternoon, Your Honor. Melanie Bates, appearing on behalf of Thomas Basher, P 76080.
Good afternoon.
Thomas Basher, Your Honor.
Thank you.
And Your Honor, Mr. Basher is executing a plea form as we speak.
Thank you.
May I approach?
Sure. So he's going to plead straight up to count 2. Count 1 is going to be reduced to a misdemeanor use of, correct?
That is correct.
All right. Mr. Basher, did you
And Your
discuss?
Honor, I'm sorry, it's going to be a no contest plea.
No
in order to
contest?
Stipulate to the police report.
Do you have a copy of that incident report, counsel?
I do.
I don't. Mr. Basher, did you discuss your rights and options with counsel?
Yes, Your Honor.
You understand those rights and the options they give you?
Yes, Your Honor.
You understand the possible penalty for these charges?
Yes, Your Honor.
You understand that when you say no contest, you're literally saying to me, Judge, I'm not fighting these charges.
Yes, Your Honor.
If I can find a factual basis that supports a guilty plea, I'll move forward and we'll ultimately have a sentence. And you understand all that?
Yes, Your Honor.
Understanding all of that, are you pleading no contest freely and voluntarily today?
Yes, Your Honor.
All right. All right, I do find a factual basis to accept the pleas, and I will do so. I'll dismiss count one.
Thank you.
You're welcome. Counsel, what's your thought?
In
Should I
regards,
send him for a pre-sentence investigation?
Your Honor, I was gonna ask for immediate sentencing, and here's the reason why.
Go ahead.
We have a sentence agreement for the 18 months probation, drug screening and treatment if necessary, along with the community service. As the court may recall, Mr. Basher had a case in the Washtenaw County Circuit Court. And this case predates that. This case is 2022. Mr. Basher was sentenced in Washtenaw County Circuit Court on June 24th. He was sentenced to 2 years probation, 1 year in the Washtenaw County Jail with treatment. He just had to resolve this case before he can be released
Good.
into his treatment program.
What program is that going to be?
I'm not.
Okay. Back to counsel. All right, anything else I should consider, counsel?
Your Honor, I would just say, Mr. Basher is taking responsibility. He's feeling better. He's looking better. He's been in custody. He's going to take advantage of the programs that he can have so
Good.
that he can be better for himself,
Yep.
better for his family.
So how long have you been in custody?
So far, like 9 months.
Okay, so before you went in, were you working?
Before I got like incarcerated.
Where were you working before you went in?
Just temporarily with my son and his family.
What kind of work?
They own the pawn shop.
Okay. Anything else you want me to consider?
I'm done. I'm 44 years old and I've had enough, and I'm just ready to just be.
Well, it sounds like they certainly got a plan in place in Washtenaw to help you make that change.
Yeah. Yeah.
Work the plan.
I'm doing all I can do. I've been in there with no incidents and.
And Your Honor, do you know how
Go
it
ahead.
would work with this probation and what, because he'll be living around the Washtenaw area in treatment.
I'm inclined to put him on a non-reporting probation,
Okay,
just because I know he's being monitored by Washtenaw.
yeah, okay.
2 years. I have 2 years
Yeah.
probation in Washington.
Yeah.
Okay, thank you, Judge.
So when's he going to be released from custody? I mean, 80 hours community service. How's he going to do that if he's in?
That is true. I didn't even think about that.
They have me doing community service at the treatment when I go there. They've already got me signed up for it. So I got community service like 60 some hours for Washington to do as well. So I mean, like,
Here's what I'm going to do. I'm going to make it easy. Everything on this, you're already doing in Washtenaw. So I'm going to tell you, sent to this court, 18 months, non-reporting probation, just stay out of trouble. If you violate in Washtenaw, I'm going to consider it a violation here. New charge, obviously, violation here.
Yes.
All right. At that point, I've got a year and 93 days hanging over your head.
yes, sir.
Don't make me use it.
Yes, sir.
All right.
Thank you very much, Your Honor.
Okay, that's it. Good luck in Washtenaw.
Thank you.
Thank you.
Hey,
Have a good
Mike.
day, everyone.
Hey, can I pick your brain about something? Come on. Do you remember the guy's name?
Today,
Moynihan on behalf of the people, P 84692.
And good morning, Judge. David Cripps, P 34972, appearing on behalf of Darren Scott Reed. It's my understanding he'll be joining us shortly, but I'm prepared to argue while we await for him regarding bond.
Thank you. Just so we're on the same page, it looks like the bond is currently $200,000 cash or surety. No contact with Christian Shelby or Cynthia Reed. Can't return to 28675 Mineral Springs and release with GPS tether only. Zach, we all on the same page there? That's the current bond?
Yes, Your Honor.
Yes, Judge.
All right. Thank you. Mr. Chris, go ahead and make your argument.
Yes, Judge, I'm asking for, in my brief in motion, I'm requesting a 10% provision to be added on. The reason I'm doing that, Judge, is for a couple of main reasons. My client, of course, would have a guarantee and a promise that he would not have any contact at all with the complainant. He currently works for his father's company, Paris Sewer Cleaning. It's a small company that they have that he's very important part of the ongoing nature of the business. I've talked to his father a number of times, and he really needs his son back assisting him in on the business. And his father's a very substantial, responsible person. So I wanted to bring that to the court's attention in terms of, I don't think there'd be any danger at all that my client would miss any future court dates. My client would be residing at a different address than you just mentioned on the record. It'd be 31124 Windsor in Westland, Michigan, with his grandmother. So Judge, he's got bonds and other cases that he has to make, and we think that the 200,000 with a 10% provision would be adequate assurance of his return to court, and at the same time, a substantial amount of money would be required to get him out. Thank you, Your Honor.
On behalf of the people, Ms. Moynihan.
Thank you, Judge. My concern here is Mr. Reed does have several cases pending. He has 2 out of the city of Westland, and that's kind of how all of this got rolling. Is at the time we reviewed 1 warrant for Mr. Reed, we became aware of several others. And then once the warrant for the first Westland case, which was an assault with intent to do great bodily harm less than murder with the same victim, at the time that Westland went to arrest Mr. Reed, that stemmed from the second Westland case, that being a controlled substance possession case. It became aware that there was another incident in the city of Huron that is before Your Honor, that being an assault with a dangerous weapon with the same complainant. This defendant shows to be a high risk of safety risk for the complainant. There's been several instances where his jail calls have been reviewed, where he's made statements to his father that when he gets out, he's going to kill the complainant. He has had statements to his father of to tell another individual to set this complainant's garage on fire. He has attempted to contact the complainant 5 times, at which point he was admonished by the Westland judge, Judge McConnell, that he was not to have any phone privileges. He was not to have any contact with her, but then turned around and contacted somebody else from a phone in the Wayne County Jail and asked them to reach out to the complainant yet again on his behalf. So he's shown that he cannot comply with the rules set by the court already. I don't think that he's a good candidate for a reduction in bond. And also that address that Mr. Cripps read off, that being the Windsor Street address, he has a no contact order with as well from Westland, I believe. So I don't think he would be allowed to go back to that residence either.
I'm not aware of that no contact provision with that address. I know he can't have any contact with his ex-wife at her location. But Judge, these are things that I've had long conversation with my client about regarding not using the jail phone and to just keep quiet and let me resolve all these cases. That's the direction we want to go in. Again, I would respectfully ask that the court grant a 10% provision. Thank you.
You're welcome, Mr. Cripps. I'm going to deny your request. It's not, what I'm hearing is a course of behavior that seems to be escalating, and a man that won't follow the rules, he just does what he wants. Bond will stay as it is. Division 1, do we have Mr. Reed available? I'm going to assume nobody's there.
Judge, when we had a brief conversation with Heather with the one of the sheriffs, and he said they were bringing him and he's en route, so he should be here any minute, so we can put the
Thank
waiver
you.
on the record.
And the intention is to waive, Mr. Cripps?
Yes, Your Honor, on both cases.
Thank you.
Staff, Neighborhood Defender Service, Carrie Martin, P 84592, appearing on behalf of Mr. Joshua Patton on all cases. Mr. Patton appears by Zoom from the Wayne County Jail. It appears his device is muted. Mr. Patton, if you can unmute the device or get a deputy to do it for you, then state your name for the court.
Mr. Martin, we've also got a misdemeanor retail fraud from Van Buren. I'm hoping you can assist on that one. I think I've got a no-brainer resolution.
Great. Yes, yes,
saw
Mr.
that?
Patton, state your name.
Joshua Patton.
And yes, Judge,
Mr. Patton, can you hear us okay?
Can you hear us, Joshua?
Yeah.
Okay. And yes, Judge, for the record, I'm appointed on the 2 felony matters ending in, I believe, 29 and 30. And I also entered my appearance on the misdemeanor matter ending in 28.
Thank you. And what are we doing on the felonies?
Your Honor, this is up for a competency review. We did receive a report back from Center for Forensic Psychiatry finding insufficient evidence to rebut the presumption of competency. I've spoken with this about this with Mr. Patton a couple times, including just now, and we are unfortunately not prepared to stipulate to Mr. Patton's competency at this time. Mr. Muhammad, I see you're here now. I know this is different from what I indicated this morning, but just speaking again with Mr. Patton, he tells me he really doesn't have an understanding of how court procedures work or what's going on. I have concerns, persistent concerns about his competency. So I think the next step I need to take is to hire an independent expert to evaluate him. So I do think we need to set this for another competency review.
How far out do you want to go?
Well, Judge, I'm actually about to go on a paternity leave, and I will be back around mid-October. I don't know if you're willing to go out that far, but that could be good timing, and it would definitely give me the time to get that independent done.
Mr. Muhammad, any objections to that?
Judge, I'll leave it to the court's discretion, but my understanding is the defendant was found competent.
All right, so you faded out at the end. Understanding is what?
My understanding was that the defendant was found competent. I don't have
that was one opinion
in front of me. However,
that was one opinion. I guess I'll have to decide for myself. Let's just set it for here. All right, October 9, we'll set a competency hearing. Let's set it at 10 o'clock.
10-9. That would be
no, we got to do it at 8:30 just because if he's still in custody, that's when we get to jail.
Hopefully
so
you will not
9,
be in custody by that point.
October 9. Why so
well, if
late?
he's out, then you can contact us. We might be able to do a change the time. It might make more sense.
Thank you.
But for now, let's leave it at 8:30.
8:30 a.m. October 9th. That's a contested competency hearing. So one where I should be ready to.
Right, on
Yes.
both files, on both misdemeanor files. And I will continue the bond on each of those files. As to the misdemeanor, go ahead.
As to the misdemeanor, Judge, if you're willing to dispose of that today, Mr. Patton has quite a lot of jail credit that I believe would count for all 3 of his cases.
Yeah, I shouldn't be in jail all the way to October 9th. I ain't even do nothing.
Mr. Patton, this is not going to cause you to be in jail until October 9th. I'll speak with you about that, but this case is not holding you in jail.
Okay.
Okay.
Mr. Patton, I've got a February 25, 2024 misdemeanor charge of retail fraud. If you're inclined to plead guilty to that charge today, I'm going to sentence you, and I'm going to sentence you to time served and close the file. Do you understand that?
Can you tell me, read that back to me again?
Or perhaps not.
Go ahead.
So, Mr. Patton, you've got these 2 cases related to car theft, and the same day there was you're accused of having taken something from a Meijer store, like shoplifting. It's called retail fraud.
Yeah.
Now, if you're willing to admit to that today, the judge will just say your sentence is time served, so there will be no further punishment, and that case will be closed out.
Yeah.
Does that make sense to you?
Yeah.
Okay.
Okay. Mr. Patton, you've discussed with Mr. Martin your rights and options, is that correct?
Yeah.
You understand those rights and those options?
Yeah.
You understand that this retail fraud charge is a misdemeanor, it carries a possible penalty of up to 93 days in jail and up to $500 fines plus court costs.
Yeah.
Okay, thank you.
Understanding all of that, are you pleading guilty freely and voluntarily?
Yeah. I plead guilty. I plead guilty.
On that date in February 25, did you try to take some merchandise from the Meyer store without paying for the merchandise?
No.
Mr. Martin, you need a little time?
Your Honor, normally I would take a little time here, but as indicated earlier in this record, I do have concerns about Mr. Patton's competency, his ability to understand any of this. So it might just be best to put this off until October 9th as well.
All right. Okay, we'll see you in October.
All right, thank you, Judge. If I could just get another breakout with Mr. Patton to explain things.
Sure.
Thank you.
Heather can make that happen. Counsel appearance for Hurst.
Morning, Your Honor. Attorney Mark Meisner standing in for Megan McDonald, P86736. Now is the date and time set for pretrial.
Are you Hurst?
Yeah, come on, Hurst.
All right, looks like we got,
State your name for the record, please.
Kenneth Hurst. Looks like we got a plea worked out
We do, and my client will be playing no contest.
to both 1 and 2.
To
Count
both
1
1
and
and 2 under 771. Yes, Your Honor.
What is the name of the attorney?
Mark Meisner, MEISNER, P86736.
Okay, Mr. Hurst, did you discuss your rights and options with counsel?
Yes, sir.
Understood all that?
Yes, sir.
You understand the possible penalty for these charges?
Yes, sir.
Understanding all of those pieces of information, are you pleading guilty to both these charges today?
Judge, my apologies, but can you plead no contest today? That was our discussion with the prosecutor.
Yeah, I've got an investigative report. I can probably get the facts.
Yeah, we would stipulate to the facts.
Yeah. So you understand that when you plead no contest, you're literally saying, Judge, I'm not fighting these charges.
Correct.
And if I can find a factual basis that would support a plea of guilty, then I can move forward and sentence you. You understand all that?
Yes, sir.
All right. So you're pleading no contest freely and voluntarily today. Is that correct?
Yes, sir.
Give me a minute to read. All right, I do find a factual basis to accept the plea on both count 1 and count 2, and I will do so. What should I know before I sentence, counsel?
My client has no prior criminal record. He is an airline pilot for Delta, where he has served faithfully for 7 years. Prior to, he was a deputy sheriff in the state of Minnesota. Again.
Oh, I remember we talked about that.
Yes, sir.
I thought that was a kind of weird career change.
An insane transition. But again, client has no prior criminal history and is prepared to proceed. And Mr. Harris, if you have anything to say?
Yeah, just this was a aberration, one-time bad judgment. You know, I pride myself in being responsible and to uphold, you know, high standard of responsibility and decency. And you know, this is the only time I've ever been in trouble with the law besides a speeding ticket here or there.
Pilots are known for better judgment too.
Yes, sir. Yes, sir. And again, this is just one stupid night, and it will never ever happen again.
How's your leg?
It's getting better. It's getting better. I'm walking around a little bit without the crutch. And
no permanent damage?
Well, I've got a titanium rod in there, and so I've been trying to learn to walk back, but it's my doctor said about another month I should be good to go.
Okay.
So
you're gonna get back in the cockpit?
yes, sir. Hopefully.
All right.
Nothing further from us, Judge.
Okay. Counsel, if I get 30 days for the substance abuse evaluation, you think that's enough time?
Yeah, that should be good. How did you?
If it's not,
We already did do one.
Oh, you already got it?
Yeah, we did
Yes.
one.
Where'd you do it at?
I did it online.
Advanced behavioral rehabilitation, and we should have a copy of it with us.
What's Emily's extension?
What did you do it? Oh, May 18th, okay. Thought I had a copy, Your Honor. I'm not seeing it in my records. I apologize. But he did submit to it on May 18th.
2-6. Find out if Emily's here today, and if she is, have her come up. No?
No.
Okay.
My apologies.
That's all right. I just want to make sure. I think that's an agency we've used, so I just want to make sure that,
Okay.
that I'm going to approve an evaluation
Sure.
from them. Did they recommend any follow-up or anything?
No, they said they did not. They said there's another course I could take if I wanted to, but that was about it. I think it was.
Okay.
I can email a copy to this court as well if
Yeah, I think what I'm going to do is have you email one to Mr. Rowley.
happy to.
Where was she at?
I called Shannon's office.
I think I've got it on my phone.
I do too.
Okay.
Yeah, well,
Okay.
Okay.
Jamie looks like she's waiting for something too. So I got to ask you, hollow point or FMJ?
No, it was a full, just a regular training round.
Lucky.
Just,
Lucky.
yeah. I'm definitely. I could not be here today, so
I knew a kid back at State, Michigan State, that was one of those guys who was lucky enough to grow up where he could step out of his back door and the range was right there.
Uh-huh.
And I won't give you the whole story, but just huge brain fart. Shot himself in the thigh with a 357 python.
Oh.
And the doctor told him that the only thing that saved his leg was the fact that it was a hollow point.
Oh, really?
Which is counterintuitive.
Yeah.
But he said when you looked at it, the X-ray of his leg, although there was a big spot where the bone was all shattered, his leg was just like peppered, right?
Yeah.
All the fragments of the bullet. And the doctor told him that if it hadn't done that, he probably would have had such a big gaping wound,
Hole in his leg.
that he would have bled out because he was home all alone.
Yeah.
But I always thought that was counterintuitive.
Yeah.
Did you?
This courtroom moment wasn't about shouting. It was about control, truth, and a decision that could change someone's life. A man stood in front of the judge, ready to accept a plea. But even before accepting it, the judge made one thing clear. The court decides the outcome, not the agreement on paper. Because no deal, no condition, no recommendation is final until the judge sees the full picture. Then the case took a deeper turn. The victim, his own mother, spoke up, not with anger, but with concern. She didn't ask for punishment. She asked for help. She explained how her son had been struggling for years, dealing with problems no one was addressing properly. And that's when the judge shifted the entire direction of the case. Instead of focusing on punishment, he focused on treatment. He ordered a full evaluation, possible mental health support, and strict probation conditions. But the warning was just as clear. If he refuses help, jail will follow. Because sometimes the court isn't just there to punish, it's there to force change. So here's the real question. Should the system focus more on fixing the problem or just punishing the mistake? Like and subscribe for more real courtroom moments.